AI is not the malpractice risk for law firms. Blind trust in AI is. That's the distinction every attorney, managing partner, and legal marketer needs to understand right now, because we're no longer in the phase where AI mistakes are just funny screenshots on social media. We're now seeing AI generated errors show up in real legal filings, in real courts, with real consequences for real attorneys. And the lesson from the courts is becoming pretty clear. If fake cases, bad citations, or inaccurate legal arguments make it into a filing, the judge is not going to sanction the AI tool. The responsibility lands on the lawyer. The attorney whose name is on the document owns what is in that document. That's why AI in the legal industry has quickly moved from being a productivity conversation to a professional responsibility conversation. And for law firms, this is where the risk gets serious. AI can absolutely help attorneys work faster. It can summarize documents, organize research, brainstorm arguments, draft outlines, review intake notes, assist with marketing content, and help teams move more efficiently. But AI can't replace legal judgment. It can't replace verification, and it can't replace the duty of candor on the court. And it cannot replace the lawyer's responsibility to protect the client. The problem is not that AI sometimes gets things wrong. Every tool has limitations. The problem is when law firms treat AI output as if it's already reliable simply because it sounds polished. That's one of the most dangerous parts of generative AI. It doesn't always look wrong. A fake citation can look real. A made-up case name can sound plausible. A summary of the law can feel confident. A legal argument can read smoothly. But confidence isn't accuracy. And in law, sounding right isn't enough. Over the last year or more, courts have seen a growing number of examples where lawyers submitted filings that included AI-generated hallucinations. These can include cases that didn't exist, quotes that were never written, or authorities that do exist but don't support the argument being made. That last point matters. The risk is not only fake cases, it's also real cases being misused. AI might cite an actual case but misunderstand what the case stands for. It might pull language out of context. It might blend together different legal principles. It might summarize a ruling in a way that's close enough to sound believable but wrong enough to damage the argument. In litigation, that can be a major problem, and courts are reacting. We've seen reports of attorneys being sanctioned for AI-related filing errors. In some cases, the consequences went beyond a financial penalty. Attorneys have faced removal from cases, referrals to disciplinary authorities, disclosure obligations, and reputational damage. That should get every law firm's attention, because once an AI mistake reaches the court, the issue is no longer which tool did you use. The issue becomes, why did your firm allow this to be filed? That's a governance question, it's a supervision question, and it's a training question. And depending on the facts, it can become a malpractice question. The American Bar Association has already weighed in on the issue. Formal Opinion 512 makes it clear that lawyers using generative AI need to think about multiple professional duties, not just whether the technology is useful. That includes competence, it includes confidentiality, communication with clients, supervision of other lawyers and non-lawyer staff. It includes candor to the tribunal. It includes making sure claims are meritorious, and it includes reasonable fees. And that means AI touches far more than legal research. If a lawyer uses AI to help draft a motion, there are verification issues. If a paralegal uses AI to summarize client information, there may be confidentiality issues. If an intake team uses AI to communicate with a potential client, there may be supervision and communication issues. If a marketing vendor uses AI to create website content, ads, or client-facing claims, there may be legal advertising and ethics issues. If a law firm bills a client for work that was significantly accelerated by AI, there may be fee and disclosure questions. So this is not just about fake citations. Fake citations are the loudest and most obvious version of the problem, but the broader issue is this. Where is AI entering the law firm's workflow, and who's responsible for checking the output? That question matters because many firms may already be using AI in more places than the partners realize. An associate may be testing a research tool, a paralegal may be using an AI assistant to summarize documents, an intake person might be using AI to draft follow-up messages, or a marketing agency may be using AI to write blog posts, landing pages, emails, or ad copy. A CRM system may have AI features built into the platform. A chatbot may be answering basic questions on the website. None of that's automatically wrong, but if the firm has no written policy, no approved tools list, no training or vendor review, and no verification process, then the firm may not actually know how AI is being used on its behalf. And that's where exposure builds. One of the most important studies on this issue came from the Stanford-affiliated researchers who tested legal AI research tools. The finding was not that these tools are useless. The finding was that even legal-specific AI tools can still hallucinate at meaningful rates under tested conditions. That matters because some firms may assume that if a tool is designed for lawyers, it must be safe to trust. But legal AI does not mean verification no longer required. It means the tool may be useful within a controlled process. That controlled process is the key. Law firms should not respond to this by panicking and banning AI completely. That's probably unrealistic, and in many cases, it may cause firms to fall behind. AI is going to be a part of the legal industry. The better question is whether firms can use it with discipline. The firms that get this right will not be the ones that move the fastest with no guardrails. They'll be the ones that move carefully, document the process, train their people, and keep human judgment at the center. So what should law firms actually do? First, create a written AI policy. Don't rely on informal conversations or assumptions. Put the rules in writing. Define which tools are approved, which tools are prohibited, who can use them, what types of work they can be used for, and what must be reviewed before anything leaves the firm. Second, protect confidential information. Law firms need clear rules about whether client data, case facts, documents, medical records, financial information, or privileged communications can be entered into AI systems. If the tool is not approved and the data handling is not understood, the safest answer should usually be no. Third, require human verification. This is a big one. If AI helps with research, every citation needs to be checked against trusted legal research sources. The case has to exist. The quote has to be accurate. The legal proposition has to match what the case actually says. And that review should happen before anything reaches a court, client, opposing counsel, or public-facing channel. Fourth, train the entire team. This is not only an attorney issue. Associates, paralegals, intake staff, marketing teams, outsourced vendors, and administrative staff may all interact with AI in some way. If they don't understand the risks, the firm still carries the consequences. Fifth, review vendors. This is one many firms overlook. If your marketing company, your CRM provider, intake platform, chatbot provider, or content team, if any of them are using AI on your behalf, you need to understand how. What data are they using? Are they entering confidential information into third-party tools? Are they reviewing outputs? Are they making claims that comply with legal advertising rules? A law firm can't outsource responsibility and then ignore the process. Sixth, document the workflow. If the firm ever has to explain how it uses AI, it helps to show that there's a system. That system might include things like approved tools, internal policies, training records, verification checklists, vendor documentation, and review procedures. That kind of documentation will not prevent every mistake, but it shows the firm took the issue seriously. And finally, keep the lawyer in charge. AI should support the legal team. It should not replace the legal team's judgment. That's the bottom line. Speed is valuable, efficiency is valuable, better workflows are valuable. But none of that matters if the work product is inaccurate, if client trust is damaged, or if the firm ends up explaining to a judge why fake or misleading information made it into a filing. So my message to law firms is not don't use AI. My message is do not use AI casually. Don't let every person in the firm experiment without rules. Don't assume your vendors are handling it properly. Don't trust citation because it looks real. Don't let AI-generated work reach a court, a client, or your website without review. AI is here to stay in the legal industry, but the firms that win with AI will not be the firms that blindly chase every new tool. They'll be the firms that combine technology with judgment. They'll use AI to move faster, but they'll verify before they act. They'll create policies before a problem forces them to. They'll train their teams before mistakes become public. They'll understand that in law, accuracy still matters more than speed. Because at the end of the day, AI does not sign the filing, the lawyer does, and that means the responsibility still belongs to the firm.